Good afternoon, everyone, to our webinar on the skills in demand 482 visa. Just a general outline of how the 482 visa has changed since December 2024. What were the changes? How can employers sponsor overseas or onshore workers now? And really just some pointers and guidelines at the end about how to lodge a successful application. And then we can have some questions at the end. All right. So who are we? My name is Christian Toth. I'm one of the senior migration lawyers at NB Migration Law. Our founder and principal lawyer is Agnes Kemenes. The firm itself has been around for more than 25 years now. We've started out as a sole migration practice, and the firm has grown over the past 25 years into multiple branches across Queensland, New South Wales, South Australia, Victoria, and currently we are offering 4 services in 4 major areas, which you can see on the screen. So all divisions are equally equipped. As I said, the practice started as as a migration practice and has grown itself into a 4-division practice with property, employment, and commercial starting out as a complementary service and have grown themselves out to be completely separate divisions. So whatever your needs may be, whether it's solely employment, a mixture of commercial and migration, or any mixture of the 4, we can assist with that. That's the current structure of the firm. As I said, today's agenda is going to be really 4 major points, starting out with just a short discussion about the 482 itself, its current framework, what are the changes, how do they impact visa applicants and their employers, what businesses need to be aware of when they are thinking about potentially sponsoring someone on an employer-sponsored visa, what would be the applicant's pathway to permanent residency through the 186 visa, how can employers assist or facilitate that process, and also at the end, it's really just a short review of the list, but I believe we also included a preliminary slide which will have a QR code for you on this slide. So there's a QR code which will take you to the current occupation list as it is in place at the moment. But really, with the new occupation list that's been in place since November last year, the Department of Home Affairs has been undertaking a lengthy migration review, the result of which is the new occupation list. They've added a lot of occupations. They've also culled the list. So as you see, there are a fair few occupations which also have been removed because there was just no reason. The economy has changed. There are different occupations which are really in demand for in terms of Australia's growth, and the prevailing federal government is the one that usually prescribes what occupations are required or are eligible for sponsorship. That's usually tied to some kind of political agenda as well, naturally. So if we have a housing plan, if we have a housing shortage or supply issue, as it is at the moment, then trade occupations are still very dominant. Healthcare remains dominant. It has been dominant for the past 10 years, but especially since the COVID-19 pandemic. Now, an emerging area would be information technology or IT, particularly cybersecurity. Just if we think about the recent breaches when it comes to, I believe it was Medibank and Optus, the cybersecurity breaches, Australia is really putting the emphasis on allowing Australian companies to equip themselves with the skills and talent and the workforce required to protect themselves as much as possible against cyber threats. Engineers and workers in the horticulture, agriculture industry have always been dominant. Now they've made it somewhat easier to sponsor workers in the horticulture and agricultural industries. We're not particularly talking about low-skilled workers in most instances. We're talking about individuals with a bachelor degree, individuals who have extensive experience working on the farm, working on soils. So it's not so much the labor aspect of the work. It's more the technical, the scientific aspect that they would like to push within that industry. So why did they change the list beyond the prevailing political agenda? That's because the list hasn't been altered in a major way for the past 7 odd years at least, and it wasn't quite fit for purpose. It didn't allow migrants to have a clear understanding of how they're going to get the permanent residency. It was fostering short-term or long-term temporary stay in the country, and that's not what they believe would be beneficial for the country. They now have one list, whereas previously we had multiple occupation lists. And they've broken down the list into 3 categories, which you'll see on the next slide. So we have 3 categories under which an employer can sponsor someone for a 482 visa, and that's the specialist skill stream, the core skill stream, and the labor agreement stream. So if we start with the specialist skill stream, that's the highest. That stream allows employers to sponsor a lot of occupations which also have been taken off the list. But there's an exemption under the specialist skill stream if the employer is willing to sponsor someone who's in a professional occupation. So generally white-collar jobs is what we're discussing here, not trade occupations. And if they are willing to nominate a salary of $135,000 or more, then they can access the specialist skill stream. That stream is really for your mid to high management or your really experienced professionals, your engineers, your cybersecurity specialists, C-suite individuals and directors and so forth. Really those very experienced, very highly qualified, skilled migrants who we may need to either lead the business or educate the younger staff. That's been a general feedback from our employers within Australia, is that there's a large segment of the labor market that is relatively junior. They have less than 5 years of experience, so they are lacking that really experienced and highly qualified individuals who could oversee a business operation. Then we move down to core skills stream, which is your middle ground, your straightforward pathway. That is the most commonly used stream. So that's for everyone who is on the core skills occupation list or the CSO list. That's the new list that was released in November 2024. And because of the government removed a lot of occupations from the list, in exchange, they've actually reduced the required experience that the visa applicant must demonstrate to secure a 482 visa. So previously, they had to show they have 2 years of full-time or equivalent part-time experience. Now that's been reduced to 1 year full-time relevant experience if they have a relevant, not a relevant, but a qualification of a particular standing or standard. So to explain that a little bit further and elaborate, a each occupation in Australia has a qualification requirement attached to it. So for your trade workers, you would have your certificates. For your licensed trades, like your electricians, it may be a little bit higher. You have your lower tier professionals like drafts people, like civil engineering drafts people. They would require a diploma, and then you move higher to your engineers, to your nurses, to your accountants, to your lawyers, your marketing specialists, who would require a bachelor degree. So when we say that the person needs to show 1 year of experience, that's only if they also have the also meet the qualification requirement. Now, the qualification does not need to be relevant. That is not a requirement. However, it needs to be of a particular level. So if somebody wants to work as an engineer or some non-licensed professional occupation, a manager, that would require ordinarily a bachelor degree. They don't have that. They maybe have a diploma. There are some cases where they can substitute the formal qualification with experience. Not all cases, but generally there is usually a provision to allow that, to substitute a bachelor degree with 5 years of relevant experience, for example. Also, the salary needs to be between $73,150, which is the legal minimum to sponsor someone on a 482 visa, and maximum $135,000, because any higher than that, and we are going into the specialist skills stream. Now, when it comes to the salary, the $73,150 doesn't mean that just because it's the legal minimum, that is going to be sufficient to sponsor someone on a 482 visa. What we need to look at is what is the actual market rate in the geographical area where the person works in the occupation that they are being nominated. So, for example, if we have an engineer working in Sydney, obviously it's not going to be 73,150 with 2 years of experience. It's going to be a bit higher. Whereas now we have occupations such as childcare workers who might be well below the 73,150 or on average. They're not childcare workers, unfortunately, are not well remunerated. They would need to be bumped up sometimes by a substantial amount. I do have to have the conversation with employers that if their staff is generally below that 173,150, then employing someone who is going to be at that salary or higher may also result in them having to give pay rises to other professionals within the business. People talk, word spreads. So that's some of the uncommon or other consideration that we usually discuss in our consultations as well. It's not just only about the sponsorship, but how is that going to affect the business's day-to-day operations. And then lastly, we have the labor agreement stream. The labor agreement stream wasn't meant to be here. The department ran out of time when they introduced this new tiered system at the end of last year. So the labor agreement stream existed under the previous 482 visa program. They didn't finalize the lowest stream for the 3-tiered approach. Therefore, they just sort of migrated from the previous visa program to this new 482 visa program, the labor agreement stream. As you can see, the requirements are quite similar. The major difference is that the company needs to secure a labor agreement from the Department of Home Affairs. That is a relatively long process. It can take up to 6 months, whereas with the core skills stream, the application process may take anywhere between 2 to 4 months. With a specialist skills stream, it may take 1 to 2 months. So really the labor agreement stream is for employers who want to sponsor individuals who are not on the skills occupation or the core skills occupation list, the CISO. They're also not paying them $135,000, or they may even want to request a salary concession if eligible on the 73,150. So labor agreement stream is for your lower skilled workers, your laborers in the construction industry, in farming, who are not, the occupation itself doesn't require qualification, maybe, like your concreters, for example. In some instances, truck drivers, and really the lower end of the skill spectrum. What have been the key changes since the last visa regime? As I said, the reduced work experience from 2 years to 1, that's really now assisting a lot of migrants who maybe just recently finished their qualification overseas. They may have a little bit of experience. They just stick toward the 1 year, and they're wanting to secure employment in Australia. It's also assisting graduates in Australia, because previously graduates would struggle out of university a little bit. Maybe it would take 3 to 6 months to actually find work in their profession. And after finishing university, they can apply for a graduate visa, which is for 2 years for professional workers, 18 months for trade workers. So you see how previously someone who was, for example, a trade worker, they just finished their qualification, coming out of school, want to work, but they only have an 18-month visa and they have to show 2 years of experience to be sponsored by an employer. That was a problem previously. Now it's not. They have plenty of time on the 2-year visa to accumulate 1 year of experience in their occupation. Also, the minimum salary last year, with the start of the previous financial year, it was increased to 73,150. The financial year before that increased it to 70,000, because it wasn't increased for about 9 to 10 years during the previous federal governments. It wasn't really touched. Now it's in legislation that the minimum salary is going to be indexed, which means from the 1st of July every year, the minimum salary threshold for the 482 is going to increase. To clarify, as long as the applications are lodged before the 1st of July, the employer does not need to comply with the increased salary threshold. They just need to comply with the salary threshold that was in force in the financial year when the applications were lodged. There's also no obligation to later increase the salary. They're more than welcome to reward employees. That's not a problem, but there's no obligation to increase it. They just need to ensure that they just pay the person the salary that was nominated in the application that was submitted to the Department of Home Affairs, and that they are complying with Australian labour laws. There's also increased flexibility with visa holders themselves. Previously, there was only a 60-day grace period during which the 482 visa holder, so as the visa applicant and later the visa holder, can actually stop working for an employer and seek other employment, but they were not allowed to actually commence employment while they were searching for another business to sponsor them, which created issues. Obviously, an employer would like to test them, put them on probation, see how they are performing before committing to a relatively major financial commitment of sponsoring someone on a 482. Now, with the new changes, there's a 180-day grace period. During that time, the 482 visa holder can leave the sponsoring business, whether they are resigning, they've been terminated, whatever is the case. They can go to another company. They can work there for up to 180 days consecutively. So that's paid employment. Also, it doesn't need to be in the same occupation in which they were sponsored previously. They can work in another occupation. By the end of the 180-day grace period, however, the employer needs to lodge a sponsorship application, or the visa applicant needs to lodge another visa application to move away from the 482 if that's the case. So there's a 180-day grace period. After that, if the person is still working for another sponsor or not in the occupation, they may be liable for visa cancellation. 6 months is generally sufficient for a person to secure employment with another employer, especially if we are already holding a 482. Lastly, there is a faster pathway to permanent residency, which we'll also touch on later. For now, all I would say is that all occupations which are on the core skills occupation list, the CSO, they actually have a relatively clear pathway to permanent residency, so they can be sponsored by an employer for up to 4 years in most cases, and after 2 years, the employee can be sponsored again for permanent residency. Therefore, we usually recommend that the 3-year sponsorship is usually sufficient to facilitate that process. A few points just for business owners about how to navigate the system. This slide and the next slide will have some pointers as well. This one is really just about the fact that employers should have the core skills occupation list ready. It's readily available just through most search engines like Google, Bing. They can easily be located on the Department of Home Affairs website. I encourage business owners or HR managers to read through that list, at least have an understanding of what would potentially work for the business in terms of a long-term workforce planning, and take a longer-term view, maybe a 12 to 24-month view, because it does take some time. It usually takes, the application process may not take as long, but really from starting the application process all the way to the person relocating to Australia, it usually takes 6 to 12 months. That is why we always encourage employers to come to us early. Even if you're not ready to proceed, we are more than happy to just give you a free initial consultation and discuss what your long-term workforce requirements and needs are, see how we can meet that, maybe brainstorm a little bit as well in terms of whether the 482 is the most appropriate visa program to achieve that, or if we have to look into other subclasses as well. Now, we collected, I would say, the 6 most pertinent points when we talk about the 482 sponsorship and the visa program itself. First is know the rules. So by that we mean seek advice. Doesn't matter where it's coming from, as long as it's competent. Not just about the visa application and the nominations process, but also how to remain compliant once the applications have been finalized. So just simply because the Department of Home Affairs has approved all the applications and granted the person's visa, and the person is now onshore and they are working, it doesn't mean that the process is actually concluded. There are ongoing obligations and compliance requirements placed on the employer, such as complying with fair work and industrial relations obligations, employment law in general. Another one is when nominating someone, consider how that person fits the overall business structure and what they are actually going to do within the business. The department specifically assesses whether the occupation makes sense within the business structure. That's the genuine position requirement. One can get a little bit creative and push the envelope. For example, marketing specialists are generally required in every business. We can always make the argument that every business needs to market themselves, market their services, advertise their services. But for example, if we are trying to sponsor an electrician in a studio with the primary purpose of preparing photographs and really photography, then you might see how that's become a problem. So I generally just say, layman's terms, it needs to pass the pub test. It needs to make sense. If a government official reads it when the application is lodged, they have to have an understanding of why the employer wants to do this, or the employer needs to present a compelling business case. Lastly, record keeping. One of the most commonly breached obligation by employers. They just don't maintain records. They don't have a signed employment contract. They don't have the pay slips in order. They don't have superannuation payments in order. So the HR side of the business operation needs to be well organized, or at least it needs to be in order, because the Department of Home Affairs can and usually does, in some cases, conduct compliance checks on employers and request records in terms of which reflect that the person is being paid the salary that has been nominated in the occupation. Also, that they're still working there, what their actual day-to-day tasks are. The Department of Home Affairs can actually attend locations if they deem it necessary, in very, very rare cases. That usually occurs with farms and the agricultural industry in far north Queensland or in the regional areas. But it does occur. Now, the employer nomination scheme, the 186 visa, how do people go from a 482 visa to permanent residency? What's the pathway? What's the process? As I mentioned previously, someone who has been holding a 482 visa for at least 2 years, it doesn't need to be the same employer. They just need to hold the 482 visa, and they need to work in the same industry or the same occupation, I'd like to say. Then with the same employer, they can actually transition, or a different employer as well, through the 186 visa program. So the 186 has two major streams. One is called direct entry, and the other one is called the temporary residence transition stream. That's on the slide, under the first point. The direct entry stream allows employers to sponsor workers for permanent residency straight away, even if they're outside Australia, provided they have their skills and qualifications assessed by an Australian authority and they have at least 3 years of experience. Most commonly, employers would like to sponsor someone on a 482, don't give them permanent residency straight away. They would like to see some return on their investment, completely understandable, which is why in most cases, visa holders have the 482 for at least 2 years. It might be the same or different employer. And then at the time, the employing business can sponsor them for a 186 through the temporary residence transition stream. The advantage of that, the visa applicant does not need to have a skills assessment to apply for that. So they might not have a qualification at all. They might only have experience. You see that commonly with chefs. They might have decades of experience, but they've never attended culinary school. They don't have their trade certificates. They usually are sponsored on a 482, and they can transition to a 186 through the TRT stream. And now there's a clear pathway for occupations which are on the core skills occupation list. So the CISO occupations on that list generally have a pathway through this process with or without a skills assessment. Keep in mind that when you are re-sponsoring an employee, if you're transitioning them from the 482 to the 186, next time when you're sponsoring them for the 186, you have to consider that if their salary has not been increased on the 482, then the new employment contract for the 186 will need to include an increased salary, because the TISMIT, the minimum legal salary, is indexed from the 1st of July every year. So when you lodge a new application, you have to comply with the new minimum salary requirements or the new market rate. So if that's going to be 2 years after the 482 is granted, 2 years down the line, the person's salary may need to be increased by about $5,000 to $10,000, approximately, depending on the occupation. That's really the gist of the process. We don't want to overload you with information. So really, if you have any questions, we can spare another 10-ish minutes to answer any questions that you may have strictly about this process. If you would like to know more, we are more than happy to arrange an obligation-free initial consultation, so we don't require payment. That initial consultation is really for us to understand if we can assist you, and for you to understand whether you would like to engage the visa programs at all, whether that's appropriate for your circumstances and for your business. So if anybody has any questions, you're welcome to put it into the chat portion. So we have our first question. Can someone that holds a higher certificate lower than a diploma in engineering be sponsored on a 482 as an engineer? Sure thing. There are a lot of engineering occupations, so it really depends on which one we are discussing. If we generally just take, for example, a chemical engineer, these occupations usually require a bachelor degree. So engineering occupations require a bachelor degree, and you cannot substitute the formal qualification with experience for engineering. So it's a difficult occupation. What you may be able to do, and I can check that right now, is there's also engineering drafts persons as well. So you've got architectural draftspersons, civil engineering draftspersons, electrical, mechanical. They usually require a diploma. However, if I recall correctly, and I can check that right now. Yes, so for drafts people, the qualification can be substituted with 3 years of experience. So in your case, you may want to consider a engineering draftsperson occupation, see if you can secure a 482 sponsorship with that, because that is still on the CISO list. You would be able to secure a 482 as a draftsperson, spend the 2 years, and then go through the TRT process with the 186 with the same or a different employer. So 3 to 5 experience. If you can prove the 3 to 5 experience, just be careful. It's really about also evidencing it. It's not just claiming it. You have to show it with documents. Then it may be a viable pathway. Yes. Another question. What are the possible options for restaurant managers which will grant them sponsorship? Restaurant managers have been removed from the CISO list. They have been struggling. So for cafe and restaurant managers, you really only have two options when it comes to employer sponsorships. One is the employer would need to sponsor the individual under the specialist skills. So that's $135,000 base salary plus super per annum. Alternatively, the person can also see if the employer would be able to sponsor them on a training visa, which is 2 years, but that's for junior professionals who haven't been in the industry for too long, maybe have 1 year of experience. Alternatively, the last option would be a regional employer sponsorship, which is a 494. For that, the person needs to secure a skills assessment through VEDassess. So you would need to show that you have a qualification and the required experience to do the skills assessment. And the employer must be located in the regional area, which is usually about 100-ish kilometers outside the major capital cities, roughly. But the Department of Home Affairs has a dedicated website for regional postcodes. If you go on Google and type in regional postcodes, Department of Home Affairs, the first link is usually going to bring it up. So you can check if the postcode you're working in and you're living in is eligible for that. Another question from Andy. Curious, what do employers undertake to sponsor people? Is there a financial cost? Yes, there is a financial cost. So for sponsors, for businesses, they really have to go through at least 2 applications that the business is responsible for. They have to get the legal entity approved as a business with the Department of Home Affairs. That costs a bit of money. They have to provide their financial documents, business registration, some proprietary documents as well. And then they have a nomination, which is the more expensive part of the application, because they have to pay an annual penalty fee upfront for sponsoring someone. That's called the Skilling Australia Fund Levy. So that really depends on the business's size. If the annual turnover in the last financial year was below 10 million, it's $1,200 per year of nomination. If it's above 10 million, it's $1,800 per year of nomination. So to give you an example, if a company is sponsoring a chef for 3 years, maybe it's a mom and dad restaurant, the turnover is below 10 million. So we're looking at 3 times $1,200. So that's $3,600 to the Department of Home Affairs upfront that they have to pay to sponsor someone. Yeah, you look, Louise, civil engineering to be more specific. You can look at civil as a civil engineering draftsperson. You can have a look at that occupation. If you want to, you're welcome to book us a consultation with that. I'm happy to sit down, go through your resume, and just really discuss whether that would be a good pathway for you. Because there are other considerations with civil engineering draftsperson, but if you've got 3 to 5 years of experience and an employer that may be willing to sponsor you, we can definitely look into that. Okay, do I need to apply for a 482 for a 3-year duration in order to be eligible for the 186 TRT? No, you don't. We recommend 3 years because the department accepts 2 years. But the issue with the 2 years is that there are really 2 issues with that. Legally speaking, the requirement is that you spend 2 years on the 482 before applying for the 186 TRT. However, that would mean your visa runs out if you've got a 2-year 482. Therefore, the Department of Home Affairs introduced a bit of leniency, saying that they will still accept the 186 TRT if the 186 application is lodged in the last 5 days of the person holding the 482 visa. It's very close to their visa expiry. So if the Department of Home Affairs has issues with that platform, because it's a digital platform, it crashes, there are some problems with it, that's an issue. If the person takes unpaid leave, that's not counted towards the 2 years. So if they take more than 5 years of unpaid leave, they can't actually do the 186 TRT. So, and you know, things happen. Sometimes people have families who are ill, there are emergencies, they have to fly offshore, they don't have the annual leave accrued to take paid annual leave. they have to take unpaid leave and just fly out because it's an emergency situation. So the extra year is really to accommodate life and different circumstances for people. Also, if somebody's overseas, when their visa is granted, they need time to come on shore and start working. That's usually takes a few weeks, few months. That's not counted either. So the 1 year is definitely there to ensure that the employer doesn't need to sponsor another 482 and another 186. They can do one 482 for 3 years, and then the person can do a 186 with the employer. If you have someone on a 482 visa, can you start the process for the 186 before the 2 years is up and lodge it at the 2-year mark? So as I said, yes, in the last 5 days, but be very careful with that. Because as I said, if the person took any unpaid leave, if they came in from offshore, then you need to make sure that they actually worked the 2 years, that they have that under their belt when the application is lodged in the last 5 days. Yes, Tony. So the staff levy is still applicable for the 482, very much so. So $1,200 for the nomination, $1,200 per year for a business under 10 million. Above 10 million, it's $1,800, and there's also a staff levy for 186. Under 10 million is 3,000 flat. Above 10 million is 5,000, the one-off payment. Now, with the SEF levy, there are some instances where the sponsoring business can request a refund if the person leaves within 1 year of the nomination. So if they've been nominated for 3 years and they leave after 6 months of their 482 being granted, there's actually the unused portion of the SEF levy, the 2 years out of the 3 can be requested from the department and they refund it. Just takes a few months to go through the paperwork and the process. Can the employer pay the employee annual leave exceeding their balance at the time of the leave taken to avoid an unpaid leave period? That's okay. First, I would say that's also an employment law question. Whether that would cause any issues. So I would have a joint advice given with the employment team, because there are other considerations for the employer if they pay access. Generally, the department it may be acceptable, but it's something that hasn't been tested because these requirements really came out in the past 2 to 3 months. So a lot of cases will be going through the courts and the tribunals and the appeal process for us to see what the department's attitude is towards these arrangements. If the employer is willing to give the employee more annual leave up front, or if there's a provision in the employment contract that the employee can purchase annual leave, that may be a different story. However, what is not required is that the person takes unpaid leave and then later on they try to make up for it. So that can't be rectified. Once unpaid leave is taken, and it was unpaid leave, that's locked into the system, so to say. So the person can't work more over time. They can't make up for it down the line. Okay. For enrolled nurse, is 494 or the 482 better option? Is there a salary requirement for both? Yes, both. So 491 doesn't have a salary requirement. The 482 does. The 491 is a points-based visa, so that's a different story. That's a bit outside the scope of what we are discussing today, because the 491 is a points and invitation-based visa, and the requirements are prescribed by each state and territory in Australia. The 482, definitely 73,150 as a minimum salary applies. It will increase from the 1st of July, most likely. For guaranteed annual salary. Okay. All right, Katie. It depends on if you're talking about within the context of a 482, if I understand it correctly. So even if you still need to you need to work full time on a 482. So the contract needs to be full time. Now the contract can specify a shift every week as to what hours and what days you're working, but it still needs to be full time. So that's 38 hours a week. Now, if you don't work for a month and you don't receive pay because you take unpaid leave for a month, you can't make up for that with double shifts. So you can't work no hours 1 week and work double. So that's time 2 times 38 next week. So that's what 76. You can't work 76 hours the next week to make up for the previous week. That is not the case. And not at this stage, at least. Our interpretation is that the department is not looking at hours worked across the 2 years, but days. What days were worked, what days were paid leave, what days were unpaid leave. So with this, that is exactly why we strongly recommend to do the 3-year nomination, because it can accommodate for all of these scenarios, whether the person takes unpaid leave, they are terminated, they have to find another employer. It accommodates for everything. That extra year, that buffer is there. Now, obviously, that extra year, that buffer is paid for by the employer. And that's something that would need to be negotiated between the employer and the employer, that they are putting up the SAF levy for 3 years instead of 2. But as I said, if the person leaves within 1 year of the nomination approval, the business can request a refund. Now, I believe I still have time for a few more questions, maybe 1 or 2 more questions. So if anybody has anything further to ask, you're welcome to do so. Otherwise, we can conclude the webinar. Can a de facto partner outside Australia be added to 482 after being granted to applicant in Australia? Yes, 100%. A de facto partner can apply for a 482. It's called as 482. It's a subsequent entrant. So you would need to demonstrate that they are truly your partner. So there's a bit of a relationship assessment, a romantic relationship assessment on the part of the department. But yes, definitely, they can be included in the application when you apply for it. They can also be added as a subsequent entrant from offshore once your 482 visa is granted. Definitely possible. Partners and your children as well, under 18, or literally up to 23, but it's much easier under 18. So yes, definitely, Louise. All right. If we have one last, yep, there we go. If the employee terminated after 3 months, can we request a SAF levy refund? Potentially, yes, Katie. Depends on how many years you sponsored the person for. If you lodged a 482 for 2 years, they left after 3 months, you may be able to request the year that hasn't been used. The department is willing to give a refund for that. We've done it previously as well. As I said, it does take a few months for it to come through. It's not going to be an immediate refund. You might receive it 3 to 6 months down the line, but the sooner you put in the paperwork, yes, it's possible. Okay. Now, if there are no further questions, not a problem at all. If there are no further questions, then I might just conclude the webinar. As I said, you're welcome to contact us. We can schedule an initial consultation. You're welcome to even ask for me specifically if you want to talk to me directly. But there are We have many senior lawyers within the business. All of them are very competent. But if you would like to talk to me personally, you're welcome to ask for me by name. Not a problem, Tony. Brilliant. All right, then. I wish you all a lovely afternoon and a great weekend. And I hope to maybe see some of you in the consultation very soon. All right. Thank you, everyone. Bye for now.